What the heck is garden variety emotional distress? Let's talk about it. On June 10th, the lively parties filed a letter motion seeking clarification on Judge Lyman's June 3rd order about the withdrawal of the intentional and negligent infliction of emotional distress claims and what that means for introducing emotional distress damages into the case at some point. As a reminder, the court said, you told me that you're going to dismiss these claims, the 10th and 11th cause of action for these two torts, so go do it. I'm not going to decide for you if it's with or without prejudice. The court's order was short and said, if you don't withdraw it and you don't produce the medical records, then I won't permit the evidence of emotional distress. So the lively parties naturally were like, hold on a minute. Are you saying we're not allowed to introduce any evidence of emotional distress? Can't we still introduce garden variety emotional distress? The court clarified that it was just referring to medical evidence. So if you lively don't produce your medical records and you keep these claims, then I'm not going to permit you to introduce medical evidence to support your emotional distress claim. That makes sense, right? You're saying that you're going to drop the claims, and if you don't, and you're not going to produce that information, then I'm going to preclude you from being able to introduce it later. But that doesn't mean that they can't introduce evidence to support garden variety emotional distress. So what the heck is that? It's been defined in a number of different ways, but the basic idea is that it's generalized insult, generalized hurt feelings, resentment that anyone might feel as a result of the defendant's conduct. So you can testify as to your own emotional reaction to the alleged conduct by the defendant. You might be able to produce witnesses that also can testify about how they perceived your emotional reaction to the alleged conduct. That's kind of garden variety. What you're not saying, or what you're not able to say, is that this emotional distress was so severe that I was hospitalized, or I had a medical condition that was exacerbated, or I developed this new condition, this new disease, or this new even mental diagnoses. So it's just sort of a step below what somebody might say that how they were harmed. For example, let's say, I can't think of a really good example, but let's say somebody was in a really, really severe car accident, and as a result, they saw someone mutilated. It's a bad example, but I'm trying to make it extreme so that you can get the difference. As a result, the plaintiff, who was traumatized by this, who had been, for all intents and purposes, totally functioning adult, no other issues, maybe sought therapy for regular stuff, suddenly developed PTSD, was not able to drive again, developed a phobia, developed a immunoresponse, had, all these other medical conditions that were exacerbated. Maybe there was like a latent medical issue that the PTSD of the incident kicked up. And so that's all outside or beyond garden variety emotional distress, because it sort of teeters into the medical realm, and there's documentation that would need to be used to prove that it wasn't just your standard hurt feelings, or, hurt feelings doesn't really apply to a car accident, but sort of your standard distress that you would experience from the alleged allegations or the alleged conduct. It's something more. It's something that required some significant medical attention, whether mental or physical. So if emotional distress was kind of valued on a scale, the medical stuff would be at the high end and would have the high ticket value. And then garden variety is sort of on the lower end and a lower ticket value. In other words, it was bad, I was damaged, but it wasn't the worst. So applying this to the lively Wayfarer case, we still have all the federal and state workplace retaliation and harassment claims, all of which contain a damages element. And that damage element will have to be proven by garden variety emotional distress, which would come from the plaintiff's own testimony or people that would speak on behalf of her emotional state. Usually that's family members, husbands, wives, sometimes children. Adult children, not children, and maybe close friends that could testify as to what impact the alleged conduct had on the plaintiff. Ultimately, it will be up to the jury to decide how to value that garden variety emotional distress. There's a lot of things that they can take into consideration for how they will value it. And it's kind of an open question of how juries decide the amounts. Sometimes they value it very high, sometimes they don't value it very high. That's always a question mark for attorneys, how juries are going to rule on emotional distress. In employment cases, juries are likely to look at the impact that the adverse action and the alleged conduct, if proven, had on the plaintiff. So, was their reputation totally damaged? Did it impact their marriage? Did it make them lose friends or other job opportunities? Or did they lose out on a big bonus or promotion or career advancement opportunities? Those are the kinds of things that they would consider in determining how much garden variety emotional distress should be awarded to the plaintiff. This comes in at the very end. Obviously, the jury first has to find that there was workplace harassment, discrimination, or retaliation. And if they do find that did happen, they also then have to determine whether or not the plaintiff was damaged. And then at that point, the jury would determine how damaged they feel the plaintiff was.